Hello, my holy sisters and brothers. It's here. It's Erev Yom Kippur. We're getting ready for the big day, the Day of Atonement, the day of casting the lot on the two goats of Yom Kippur, as we learned in Tractate Yoma. I shared a little idea on the Facebook page. No sense rehashing it now, but it's worth reading. It's just very short, little idea about how we can relate the two goats of Yom Kippur to our lives right now. But I know everybody's busy getting ready, so let's get on with it. Let us light up the darkness. Who's in the house on Erev Yom Kippur? Sharon in New Jersey, Bill in Missouri, Karen in Northern California, Renee in Indiana, Melissa in Great Neck, Bella in Florida, Paul in Minneapolis, as well as Marjorie in Georgia. And I reload, load. There we go. Bella in Florida, Paul in Minneapolis. Yes, okay. Our daf today is page 42 here in Tractate Kiddushin, the 20th volume of the Talmud. We're working our way through Mishna number 1 in chapter 2. We're back to the laws of betrothal in the sense that a man can appoint an agent to create the betrothal to a woman for him, and a woman can appoint an agent to receive betrothal, or to be acquired by the man, as it were, the technical jargon, in betrothal. And we saw that a man can send the get to be divorced from his wife via an agent, and a woman can appoint an agent to receive a get. So that's the Mishnah, and now we're learning a little bit more about the laws of agency. Appointing an agent as a legal matter to do an action for you, or to receive an action for you, as it were. We pick this up at the very bottom of page 41b. The Gemara poses a question with regard to the basic derivation of the halacha, the law of agency. So this works out well according to the opinion of Rabbi Yehoshua ben Korcha, who explains that the verse from Exodus 12:6, and the whole assembly of the congregation of Israel shall slaughter it in the afternoon, talking about the Pesach, the Passover lamb, slaughtered on the afternoon before Passover begins. This was done when the temple was standing in Jerusalem. And this verse taught the law of agency with regard to offerings, right? This idea that a group would register to enjoy the Passover together. So one of them would go to the temple with the lamb or the kid, the young goat, slaughter it there at the temple, give it to the priest to sprinkle some of the blood on the altar, and then he would bring the slaughtered animal out to the place where the group was going to spend Passover together, and they would roast it and eat it that night. It's one of the laws of Passover. You can't leave any of that till the morning. In the vast majority of the Jewish world, since the temple was destroyed, we don't eat a lamb or a kid roasted on Passover because the temple is destroyed. That's one of the reminders. But at any rate, one person did the slaughtering on behalf of the group. And that's how one of the sources for this law of agency, at least with respect to offerings. And as it is taught in a Baraisa that Rabbi Yonasan says, from where do we derive that all of the Jews, right, the entire nation of the Jews, can fulfill their obligations, now we're on 42a, with one Pesach, with one Passover offering, right? We saw that groups, like 10, 15 people who were registered to eat one particular lamb or kid, they would have one person slaughtered on their behalf. But now Rabbi Yonasan is saying that if necessary, if there were no lambs in the world and one kid in all the world that the Jews could get their hands on, then one person could slaughter it on behalf of the entire nation. How is this possible? Although it is impossible for all of the Jewish people to each eat an olive bulk, which is the minimum amount that you have to eat from the goat or the lamb, so they couldn't all eat from the same lamb, they nevertheless would fulfill their obligation to sacrifice the Pesach by sacrificing one animal. As it is stated with regard to the Pesach, quote, and the whole assembly of the congregation of Israel shall slaughter it in the afternoon. Not them, but it. Slaughter it. Is it so that the whole assembly slaughters it, but only one person from each group slaughters? Rather, it can be derived from here that all of the Jews can, this is a hypothetical, all of them can fulfill their obligations with one Pesach, despite the fact that everyone will not be able to eat from it, right? Only a few will be able to eat from it, but everyone could fulfill their obligation to bring the offering if one person was sort of deputized, was made an agent on behalf of the whole nation to slaughter and bring the offering. Since Rabbi Yonasan derives from this verse that one offering could theoretically suffice for the whole nation, from where does he derive the law of agency with regard to offerings? Right, since the previous derivation was that this verse teaches that one person is deputized in each group to bring the offering for that group. If we follow Rabbi Yonasan, right, just in his view, that the whole nation could satisfy their obligation if one person brought an offering. That's what this verse teaches. So then from where would Rabbi Yonasan learn that each group is deputizing as an agent one person to slaughter their lamb? And the Gemara answers he derives it from that very same verse, as it can be seen that one person slaughters the animal on behalf of the rest of the assembly. And the Gemara rejects this. Perhaps it is different there, since the one slaughtering the animal has partnership with them in the offering. Right, one person who's slaughtering on behalf of the whole nation, he's not partners with the whole nation in the same way that these groups that have formed to eat, each group has planned, when the temple is standing, each group plans in advance to be a group that will have one lamb slaughtered for it and that they will eat it together and celebrate the Seder, etc. So those people in their little group, they are partners with each other. And so it would seem different to say that with these partners, appoint one of the partners to go slaughter the lamb and bring it back. We're not going to be able to learn out from that a law of agency for the whole nation, or we can't learn a law of agency for the whole nation and extend it to a group of partners. It's a different situation. So rather, Rabbi Yonasan derives agency with regard to offerings from a different place. He derives it from Exodus 12:3. And they shall take to them, every man, a lamb, according to their father's houses, a lamb for a household. And this demonstrates that one person takes a lamb and slaughters it on behalf of the entire family. So the Gemara asks, but perhaps there too, there is agency, since the one slaughtering the animal has partnership with them. In other words, okay, that verse teaches that the head of a household is slaughtering on behalf of the household. Okay, but those people have a relationship. How can you learn out the law of agency generally between people who don't have a pre-existing relationship, that they can appoint an agent for offerings, from a verse that teaches about people that do have a pre-existing relationship? So the Gemara rejects this argument. If so, why do I need two verses to teach the same law? If the law stated in this verse is not applicable for where it belongs, i.e. with regard to an agent who is a partner in the offering, apply it to where it does not belong, so that even one who does not have a share in the offering can act as an agent. But the Gemara rejects this line of reasoning. This verse is required for him to teach a different law, that of Rabbi Yitzchak. As Rabbi Yitzchak says, this verse is the source for the law that a man, i.e. an adult, can acquire an item on behalf of others, but that a minor cannot acquire an item on behalf of others. If you're going to appoint a person to be your legal agent, you would want to appoint an adult to do that. In fact, legally you must. You can't appoint a minor to be your agent. And the Gemara answers that law that only an adult can acquire an item on behalf of others, that's derived from yet a different verse, Exodus 12:4. According to every man's eating, you shall make your count for the lamb. By employing the term man in this verse, which indicates an adult, the verse teaches that only an adult can acquire an item on behalf of others. So the Gemara asks another question, and still the verse, according to every man's eating, is required for him to teach the law that one may slaughter a Pesach for an individual. It does not have to be a lamb according to their father's houses, as implied by the previous verse. A lamb may be slaughtered even by one person, i.e. every man for himself. You have to register in groups to share a lamb, but you don't necessarily have to have a group to eat a lamb. One person, if he hasn't found a group to join, but he can make a plan to bring a lamb and eat it himself, he could do that. So the Gemara answers, Rabbi Yonasan holds, in accordance with the opinion of the one who says that one may not slaughter a Pesach for an individual. You have to join some kind of a group. You can't do it by yourself. So the Gemara asks a question from a different source, but consider that which Rav Giddel says. That Rav says, from where is it derived that the legal status of a person's agent is like that of himself? It is, as it is stated with regard to the division of Eretz Yisrael, the land of Israel, among the Jewish people, right? When Joshua would bring didn't happen within the 5 books of Moses, but they already had the law creating what would happen in the book of Joshua when Joshua led the people in, and they divided up the land according to the tribes. And there it says in Numbers 34:18, and you shall take one prince of every tribe to take possession of the land. And this indicates that the prince of each tribe acted as the agent to claim the land for each member of his tribe. So, let the law of agency be derived from here. Why is there a need to have the sources quoted above? It seems like we've been looking for a source to say that the legal status of a person you appoint to be your agent is like you yourself. He's functioning at your instruction. So, if you instruct your agent to sign a contract for purchase and sale of land, or to bring an offering, or to go commit an action, and this is in the context of betrothal and divorce, but really any legal action, right? We have lawyers, we have real estate agents, we have travel agents. This whole idea that an agent can, sign a deal and obligate you in that deal because you appointed him as your agent, seems like a good source for that would be this verse, that the heads of the tribes would acquire the land on behalf of every member of their tribe, acting sort of, as a real estate lawyer, real estate agent, etc., and binding the members of his tribe to the portions of land that he acquired for them at the time that the land was divided up after the conquest of the promised land when Joshua would lead the people in. So that seems like a great source for the law of agency. Right, so let the law of agency be derived from here. Why is there a need to have the other sources quoted above? And the Gemara answers, and how can you understand that this process of the princes claiming the land was due to agency? Maybe the head of the tribe wasn't acting as the agent of the members of his tribe, because minors cannot be involved in agency, and the princes claimed the land for all members of their tribe, adults and minors alike. Right, so if you're saying that you can't have an agent for a minor, and we haven't said why or if that's true yet, but now we're saying, well, maybe you can't have this guy act on behalf of minors, and yet the princes did act on behalf of minors, so we're not going to be able to learn out a general law of agency from here. So rather, the distribution of the land by the princes follows a different principle. It's not agency, but rather it's like that statement of Rabba bar Rav Huna, as Rabba bar Rav Huna says, that Rav Giddel says, that Rav says, from where is it derived that one can act in a person's interest in his absence? It is, as it is stated, and you shall take one prince to acquire the land on behalf of all the members of his tribe. The princes were not appointed as agents, and they could act for the benefit of minors. And so the Gemara asks, and how can you understand that it is a benefit? You're saying, okay, it's not that they appointed these princes as agents, it's that they were not appointed, but they were acting on behalf of their whole tribe because they were only acting to the benefit, right? You can always step in and act to the benefit of your absent principal, because otherwise they're going to miss it, right? It's like, somebody's announcing that there's a lost and found and nobody has come to claim it. This is the last chance. And if you don't recognize these objects as your own, they're going to be thrown away or given away, right? And you're there and you see that when the people made this announcement, in that lost and found pile, there's a jacket that belongs to your good friend, right? And you recognize that it's his. And so you step in and says, that's mine, I'll take it, right? Not for yourself, but for your friend, because otherwise the opportunity is going to be lost. Your friend doesn't lose anything by this. You know it's to his benefit. That's what he would have wanted you to do. If he decides that he doesn't want to keep the jacket, okay, he can always get rid of it later, but at least you preserve that possibility for him. So you step in and act as an unappointed agent only because it's to your friend's benefit who was absent at that time. And so maybe that's the principle that's operating here. It is not a general principle of agency. But the Gemara is going to challenge the idea that the heads of the tribes, when they acquired land for all the members of their tribes, were acting only to the benefit, right? Because if you're going to if the action that you're taking has both a benefit and disadvantage to the principal, then you can't just step in without them appointing you as their agent, right? And so the princes taking land on behalf of their people, maybe that's not only to their benefit. Let's read. And how can you understand that the princes acting in this way is only a benefit, but it was also a disadvantage? As there can be a person for whom it is preferable to him to receive a portion of land on a hill, and it is not preferable to him to receive a portion in a valley. And there's another person in the tribe for whom it is preferable to him to receive a portion in the valley and not on a hill. So the prince might claim land for members of his tribe that they don't want, and one cannot act to another's disadvantage in his absence. So rather, the verse is required to teach a different law. Like that statement of Rabbah bar Rav Huna's, Rav Huna says that Rav Giddel says that Rav says, from where is it derived? That if orphans came to divide their father's property, that the court appoints a steward for them, both to their disadvantage and to their benefit, right? Orphans cannot conduct business, like orphans who are minors, cannot conduct business on their behalf. And yet business must be conducted. I mean, they can't do their own business. They're too young to understand the ways of the world. But sometimes business has to be conducted. They have assets that need to be dealt with. Maybe there's land that's going to be taxed. Maybe some of the land needs to be sold off in order to pay the tax. Maybe some of the land needs to be sold off because they're going to miss a big opportunity to join, two pieces of land that should be joined. Whatever. Like business has to be done, and they can't do it themselves. They're too young to appoint an agent themselves, so who is going to act as their agent? The court is going to step in and appoint a steward. Now, that steward is going to have to conduct business on behalf of the orphan, so we're going to get a very trustworthy person, because when he's conducting business, hopefully he's going to make the right choices that are going to be to the orphan's advantage, but he might make a wrong choice. But if only the choices that he makes that end up being profitable to the orphans are going to end up having legal significance, then no one's going to do business with a steward who is representing orphans. He has to be empowered. He has to be their agent, whether it's to their advantage or their disadvantage. He has to have the power to act as their agent. And that's why he is a court-appointed steward. I mean, we have that same idea in modern times in secular law, some kind of conservator, right? Some court-appointed steward on behalf of those who cannot do the business themselves. So where are we? So if orphans came to divide their father's property, the court appoints a steward for them, both to their disadvantage and to their benefit. And we're using this verse to teach that law about the princes acquiring land on behalf of every member of their tribe. Now, before the Gemara completes the quote, it analyzes the statement. Why would the court appoint a steward to the disadvantage of the orphans. We understand for their benefit, but why would it also appoint a steward to their disadvantage? Rather, it means to their disadvantage in order to achieve their eventual benefit. Once a steward has been appointed to control the orphan's estate, he has the authority to act to their temporary disadvantage if they are ultimately likely to benefit from the action. And the source of this law is, as the verse states, and you shall take one prince of every tribe. Now, obviously, he's not appointed to be a jackass, excuse my language, who would make one mistake after another and destroy the estate of the orphans. He doesn't have an authority to do that. So if he turns out to be incompetent, then we're going to have to stop his authority, stop his agency, replace him, and maybe even unwind some deals where the other side of the deal was taking advantage of this incompetent steward. But hopefully a court would not appoint such a person, nor a crook. Now, with regard to the laws of stewardship, Rav Nachman says that Shmuel says, if orphans came to divide their father's property, the court appoints a steward for them, and they select for them, i.e. for each of the orphans, a fine portion. And when they have grown up, the orphans can protest the division and demand redistribution of the property. And Rav Nachman said his own statement, when they have grown up, they cannot protest, as if so, what advantage is there to the power of the court over an ordinary person? In other words, to strengthen the authority of the court, it is required that its decisions not be questioned later on. So the Gemara asks, and is Rav Nachman of the opinion that there is a consideration of, if so, what advantage does the court have over an ordinary person? Do we really care about it in the cases of stewardship? Maybe that doesn't apply to cases of stewardship. But didn't we learn in a Mishna, Ketubos 99b, right? In this, right? No, we're in Kiddushin. But when we were in Ketubos on page 99b, excuse me, I just lost my place. Well, but didn't we learn in a Mishna, Ketubos 99b, that the law with regard to the appraisal by the judges of the value of a piece of property in order to sell it is like this: where they decreased the price by 1/6 of its market value or added 1/6 to its market value, their sale is void. And Rabbi Shimon ben Gamliel says their sale is valid. And Rabbi Shimon ben Gamliel said, if so, if the sale is void, then what advantage is there to the power of the court over an ordinary person? And Rav Huna bar Chinana says that Rav Nachman says, the law is in accordance with the statement of the rabbis. And this indicates that Rav Nachman does not accept the consideration of what advantage is there to the power of the court over an ordinary person. So the Gemara says, La kasha, this is not difficult. Now we're on 42b. In this case, where Rav Nachman ruled that their transaction is void, in accordance with the rabbis, the court erred by 1/6. But in that case, where Rav Nachman ruled that the orphans cannot protest when they grow up, they did not err by 1/6. In other words, if the steward was basically competent, then whatever he does on behalf of the orphans is going to hold up. But if he purchased or sold land on behalf of the orphans and he made an error equal to 1/6 of the value of the property in the deal or more, then that deal is not going to stand because we're going to protect the orphans. And the Gemara answers they can so they cannot protest if the mistake that was made was less than 1/6 of the value of the land, but they can protest with regard to the locations. One of the orphans can contend that he prefers property in a different location than he was given. It's not a question of value. It's a question it would be much more convenient for him to, that the land was divvied up. The father's estate had land in a few different places. One of those plots of land is adjacent to where one of the sons lives, but he was given one of the plots of land that's in another city. So his brother is amenable, so they'd rather trade, and he keeps the land that's near him, and the other brother takes the land in the other city, and it should have been distributed that way, and it wasn't, so now they're going to revisit the allocation by location. Now, Rav Nachman says, with regard to brothers who divided property received as an inheritance, they are considered like they are purchasers from each other. And the laws of fraud are like those for regular transactions. If there was an error of less than 1/6 in the distribution, the transaction is acquired, meaning it is valid. And if it was more than 1/6, the transaction is void. If the error was precisely 1/6, it is acquired, and the one who received more than his fair share must return the amount of the fraud. So Rava says that which we said, that with regard to less than 1/6, the transaction is valid and the item is acquired, we said only in a case where the brother receiving a smaller share did not appoint an agent to deal with the distribution on his behalf. But if the brother receiving a smaller share appointed an agent, this law does not apply, as the one who appointed the agent can say, I sent you, my agent, to act for my benefit and not to my detriment. The agent's right to act in this capacity did not extend to a case where it was to the detriment of the one who appointed him. Now, this is very slippery, very tricky, right? So you say, I'm not an expert in negotiating deals, so you appoint, let's say, a lawyer to negotiate the deal for you. And what you're telling him is negotiate a good deal for me. And maybe you picked the wrong guy and he negotiates a very bad deal. So then you go to the other party later and you say, listen, the lawyer that I appointed him to do a good deal for me, not to do a bad deal for me. The deal that he negotiated is a terrible deal. He was outside of his agency. He was not permitted to make this deal on my behalf. This is why we have indemnity clauses in contracts. But here, under Torah law, maybe the principal can say, I only appointed my agent to do a good deal for me. This deal that he did, no way would I have agreed to that. He was not my agent to make such a deal, so I am not obligated in that deal. Is this going to work? Let's see. Rava continues. And that which we said, that if the brothers erred by more than 1/6, the transaction is void. We said only when the brother receiving the smaller share did not say, let us divide the estate by an appraisal of the court. But if he said, let us divide it by an appraisal of the court, well, then the transaction is valid. I mean, they did what they were supposed to do. If it later turned out that the pieces, weren't really divided equally, okay, somebody made a mistake, the court made a mistake. There's a limit to how much we're going to unwind transactions that really were negotiated and appraised, etc., in good faith. And this is as we learned in a Mishna, Ketubos 99b. This is the law with regard to the appraisal of an article's value in order to sell it as done by the judges. In a case where they decreased the price by 1/6 of its actual market value, or they added 1/6 to its market value, their sale is void. They have authority, they have discretion, they have a discrepancy, they can make a mistake as long as it's less than 1/6 of the value, right? About 16%. But if their mistake is greater than 16%, well, the parties to the deal can't, profit by an error of more than 16%. That's the bottom line. An error was made, so sorry, you thought you got this great deal, but you didn't. We're gonna, reset the deal and make it fair according to market value. You're not going to take advantage of the error of the agent or the error of the court that appraised. Now Rava continues, and that which we said, that if the brothers erred by 1/6, the one receiving the larger share acquired it, and he must return the amount of the fraud. In other words, we're not going to undo the deal. We're going to keep the deal in place, but just return that 16% that was the error, the 1/6. Right, that which we said, that if the brothers erred by 1/6, the one receiving a larger share acquired it, and he must return the amount of the fraud. So we said only with regard to movable property. But with regard to land, the law is that there is no fraud with regard to land. What does this mean? Halacha, where did the law actually end up? If a brother or partners divide land between themselves, even if they appraise land worth 100 dinars to be worth 1 dinar, the division stands as there is no fraud with regard to the pricing of land. And the Rima, citing the Torah, writes that if the error was more than half its value, the division is void. So very interesting that we don't have the same kinds of market value based protections for land that we do for movable property. And why would that be? Because movable property is fungible. There's all kinds of movable property, and we can establish what the market value is. But every piece of land is unique. There might be comparables, right? But at the end of the day, if brothers themselves decide to divide up a piece of land and they all agree to it, and then later one of them says, oh, I didn't know that your piece of land was worth so much more than mine, well, you should have been more careful at the time of the division, I guess is what's being said here. And with regard to land, we said that the law of fraud does not apply only when they divided it according to the value of the land, but if they divided it by measure and erred in the measurement, we do not say that there is no fraud. If they made a mistake in measuring, they thought you get 1 acre, I get 1 acre, but when they actually measured it, they made a mistake, and one guy got 1.5 acres, the other guy got half an acre, and they thought they were getting 1 acre each. That is a mistake, and we unwind the deal. And this is in accordance with the statement of Rabbah. As Rabbah said, any matter that is according to measure, or according to weight, or according to number, if it turned out to be an error, even if the error was less than the amount that constitutes fraud, that 1/6, it is also returned. Now, the Gemara returns to discuss various aspects of agency. Let's get back to the issue at hand, agency. And there is a difficulty from that which we learned in a Mishna, Bava Kama 59b. In the case of one who sends an item that causes a fire in the hands of a deaf, mute, an imbecile, or a minor, the one who sent it is exempt according to human laws, but liable according to the laws of heaven. And if he sent it in the hands of a halachically competent person, only the halachically competent person is liable. You're my neighbor. I know that you don't have matches in the house and that you're going to need some fire. So I light a torch and I send it to you, and I use a 5-year-old child to deliver it because I'm busy and I'm not thinking. That 5-year-old child, while he's walking to your house and dragging this fiery torch behind him, sets fire to a field, I'm responsible because I was the idiot who handed this dangerous object to a child to deliver it to you. That's for anyone who's not, if I use an agent who's not halachically competent and I give him a dangerous object, of course it makes sense that I'm responsible for the harm that follows. But if I send you that torch so that you'll have fire in your house, and I send, our neighbor or my adult son or some other person who is halachically competent, well, I didn't do anything wrong. I was just doing you a favor. I'm sending you the torch so that you can light your fire. And the one along the way, if he turned out to be careless or inebriated or something like that, and he set fire, okay, I didn't appoint him an agent to set fire to a field. I only appointed him my agent to carry a torch to your house. If he was so careless on the way that he caused harm, he, the agent, the one who caused the harm, is the one who is responsible for causing the harm. This makes a lot of sense. But why is the halachically competent person liable? Let us say that the legal status of a person's agent is like that of himself. So now, what did I send him to do? That's what's going to be the key question. I sent him to deliver the torch to my neighbor. That's what I appointed him an agent to do, and then he set fire, to some, shack along the way because he thought it was funny. Why would I be responsible for that? On the other hand, what if I am a bad guy and I think it's funny to, burn down this little shack, that's like somebody's equipment shed that they seem to never use. It'll be funny to have a bonfire. But I'm the worst kind of vandal. Not only do I want to see it burn, but I don't want to get in trouble for it. So I, talk some, simple person into setting the fire for me. Hey, you see that shed over there? Wouldn't that make a great bonfire? Here, take this torch, go light it up. Now, I've instructed him to do that, and he goes and does it. Now, am I responsible for burning that shed? Or is this, simpleton who listened to me and went and burned up the shed as an act of vandalism? Is he responsible, or are both responsible? Who's responsible? So that's where we're headed. So one thing is, what is the mission that I gave the agent? And if it's a transgression, if it became a transgression, was that the mission or was that his independent idea? So why is the halachically competent person liable? Let us say that the legal status of a person's agent is exactly like that of himself. And the Gemara answers, there it is different. As there is no agency for transgression. You can't appoint an agent to do an avera, to commit a sin for you. If he goes and does it, he decided to go and do the sin. So I'm the one who sent him to burn the shed. I'm not responsible. There is no agency for transgression. As we say, when there is a conflict between the words of the master, meaning God, and the words of the student, meaning a human being, whose words should be listened to? Consequently, the agent is considered to have acted of his own accord, and the one who sent him bears no responsibility. So the Gemara comments, and there is a difficulty in this from that which is taught in a Baraisa with regard to the laws of misuse of consecrated property. Right? So if something was consecrated, like I said, this lamb over here, I'm going to give it to the temple treasury. Now it's consecrated. It can't be used by me. It can't be worked. It can't be sheared. It can't be done. Nothing can be done with it that's going to benefit me. My only responsibility is to take care of it until I can deliver it to the Holy Temple when the Holy Temple is standing in Jerusalem. Okay, so what if I use that sheep? Let's say I shear it for its wool, and then I sell that wool. So now we've got misuse of consecrated property, and that is a specific sin. Okey-doke. Let's see. Where am I? Right. And there's a difficulty from that which is taught in Baraisa with regard to the laws of misuse of consecrated property. In the case of an agent who did not perform his agency, but rather he deviated from the instructions of the one who appointed him and made use of consecrated property, the agent has misused consecrated property and he is liable to bring the guilt offering for that sin. In the case of an agent who performed his agency, if he was told, if I sent somebody to shear the sheep, right, shearing that sheep that's already been consecrated, that is misuse of consecrated property. Now, if I tell the guy, hey, go shear that sheep for me, he doesn't know it's consecrated property. He's just doing what I told him to do. So, of course, it's my sin of misusing consecrated property. On the other hand, if I say to him, hey, I need some wool, take it from one of my sheep. The sheep that you can take from are in the big pen. There's a few sheep in the little pen. Those are consecrated. Don't take from there. But then, he didn't want to walk to the big pen, which is farther away. And so because he's lazy, he sheared the sheep in the small pen. So he made that choice. He's the one who's guilty. Even though he's acting on my behalf to bring me back the wool, he's the one who chose to take it from a consecrated sheep. So that's his sin, not mine. In the case of an agent who performed his agency, the owner has misused the consecrated property and he's liable to bring the offering. So the Gemara asks, the Baraisa states that when the agent performed the agency of the owner has, in any event, misused consecrated property. Why? Let us say that there is no agency for transgression. And the Gemara answers, right, so why don't we say that if, even though I sent him, I wouldn't have sent him to commit a sin, so why am I liable if he's the one who actually sheared the sheep? And the Gemara answers, the case of misuse of consecrated property is different, as it is derived by means of a verbal analogy of the word sin, chet. There's different words for sin. This is chet, the same word that is in the chatas, the sin offering, right? So we're going to derive a verbal analogy from the word chet that is used in this case, and the word chet, sin, used in the verse about teruma, consecrating the first 2% of the produce to give to a priest, as it states, and sin through error in Leviticus 5:15. where if you use teruma, you're not a priest and you ate some teruma, that would be misuse of consecrated property. So it says about that in Leviticus 22:9, lest they bear sin for it with regard to teruma. So just as with teruma, one can appoint an agent, so too with misuse of consecrated property, one can appoint an agent, although the latter is a transgression, right? In other words, if I, appoint somebody to go and shear a consecrated sheep, and I just tell him, go shear that sheep for me, and he does it not even knowing, or maybe does it knowing, I'm not sure, but at any rate, I'm going to be responsible, and in this case, there has been an agency for transgression. I appointed an agent to go commit a transgression, and he did it. So I am going to be liable for that. Now, the Gemara suggests, and let us derive a principle from misuse of consecrated property, that one can appoint an agent even to perform a transgression. And the Gemara explains this is not done because misuse of consecrated property and misappropriation of a deposit, meaning a bailee using an item that was deposited with him, these are two verses that come as one, i.e. they teach the same matter, that an agent can be appointed to perform a transgression in those cases. Misuse of consecrated property, or one who is entrusted to take care of somebody else's property and then he uses it for himself, like basically embezzlement. Those two cases, there is agency for transgression, but generally speaking, no, you can't appoint an agent to go commit a sin for you. If he does it, it's his own sin. Why? Because any two verses that come as one do not teach their common aspect to create a precedent for other cases. And the Gemara clarifies this statement. The verse pertaining to misuse of consecrated property is that which we said. But what is the verse pertaining to misappropriation? And this is, as it is taught in a Baraisa, the Torah uses the inclusive term every with regard to one suspected of misappropriating a deposit for every matter of trespass, Exodus 22:8. And Beis Shammai say this inclusive term, every, serves to render one liable for speech and thought, i.e. intent to misappropriate, like action. And Beis Hillel say one is liable only if he actually misappropriates it, as it is stated, whether he has not put his hand unto his neighbor's goods, Exodus 22:7. So Beis Shammai said to Beis Hillel, but isn't it stated for every matter of trespass, which indicates that one is liable even without actually misappropriating the deposit? Beis Hillel said to Beis Shammai, but isn't it stated whether he has not put his hand unto his neighbor's goods? Beis Shammai answered, if so, if one is liable only for actual misappropriation, why do I need the phrase for every matter of trespass? And Beis Hillel say it is necessary, as one might have thought, that I have derived liability only if he himself misappropriated it. From where do I derive that he is liable also if he told his slave or agent to do so? The verse states, for every matter of trespass. So this teaches that the bailee, the one entrusted to care for somebody else's property and he's being paid for that, is liable if one acting on his behalf misappropriates the deposit the same way as if he misappropriated himself. Right? One entrusted with somebody else's property, if he misappropriates it, he's guilty of this transgression. And if he appoints someone to misappropriate it for him, he's still guilty. So the Gemara explains further this answer, that misuse of consecrated property and misappropriation of property you're entrusted to care for, these are two verses that come to teach the same matter. Well, this works out well according to the opinion of Beis Hillel. But according to the opinion of Beis Shammai, who established this verse as rendering one liable for thought like action, and do not learn from here that the bailee is liable if one acting on his behalf misappropriates a deposit, so let us derive a principle from misuse of consecrated property, that an agent can be appointed to perform a transgression. And the Gemara answers, no, we don't do that, because misuse of consecrated property and the slaughter or sale of a stolen cow or sheep are two verses that come as one. And any two verses that come as one do not teach their common aspect to apply to other cases. And the Gemara clarifies the verse pertaining to misuse of consecrated property is that which we said. But what is the verse with regard to slaughter or sale? The verse states, Exodus 21:37, and he slaughters it or sells it, meaning a stolen cow, juxtaposing selling to slaughtering. So just as a sale is necessarily performed by means of another, since every transaction involves two parties, so too slaughter can likewise be performed by means of another, and the thief remains liable even if the act of slaughtering was performed by his agent, right? One who steals a cow and then he sells it or slaughters it is going to have a special penalty to pay when he reimburses his victim that he stole from. He's going to have to actually pay like 4 or 5 times the amount that the cow was worth, because it's bad. If he stole the cow and then he returns it, then it's a different penalty. But if he stole the cow and then he kills it, or he sells it so that it's not retrievable, then it's going to be a much bigger penalty, and that's going to apply. That penalty is going to apply even if he didn't slaughter it personally, but he had a butcher do it, or he didn't sell it. He can't sell it to himself. He sold it to some other party. That doesn't matter that there was another person involved. He will owe the penalty. So the Gemara selling to another party is how we learn out the idea that if he has it slaughtered by someone else, he's still liable to pay the big penalty. Now the Gemara quotes 2 other explanations. We're on page 43a now, and we're going to keep going just a little bit because there's going to be no class tomorrow night at the conclusion of Yom Kippur. I think we've learned in the past that's too challenging to have a class Motzi Yom Kippur. So we'll miss a day tomorrow, and then we'll try to do a double page on Tuesday, and we're getting a jump on that so that we can stay on the schedule. So the Gemara quotes 2 explanations. The school of Rabbi Yishmael taught that the word or in the verse, and he slaughters it or sells it, the stolen cow, this serves to include an agent. The school of Chizkiah taught, when the verse states with regard to the sale or slaughter, he shall pay 5 oxen for an ox and 4 sheep for a sheep. Repetition of the word for, F-O-R, is superfluous and serves to include an agent. And it teaches that the one who appointed the agent is liable for the action of an agent who commits a transgression. So the Gemara asks, this works out well according to the one who said that 2 verses that come as one do not teach a precedent that applies to other cases. But according to the one who said that 2 verses do teach a precedent, then what can be said? Why not derive from the case of misuse of consecrated property and that of the slaughter or sale that an agent can be appointed to perform a transgression? Right? The general principle is that even though in some cases you can appoint an agent to commit a transgression for you, because those are rare cases and they're unique in the Torah, they don't extend that principle to the general concept that you can appoint an agent to commit a transgression for you. You cannot do that. The general principle is you cannot appoint an agent to commit a transgression for you. And if somebody you appoint as an agent goes and commits a transgression, he's not acting on your behalf. He incurs his own liability for doing that transgression, even though he was your agent at the time. The Merciful One reveals in the Torah that an agent cannot be appointed to perform a transgression in the case of an offering slaughtered outside the temple, because the Torah states, it shall be considered blood for that man, hahu. He has spilled blood. And the emphasis of that man teaches that he is liable for his actions, but he is not liable for the actions of his agent or his principal. And the Gemara asks, we found a source for the law that an agent cannot be appointed to perform a transgression with regard to the prohibition of offerings that are slaughtered outside. Once the temple was standing, the only place that offerings could be slaughtered was at the temple. From where do we derive that this law applies to the entire Torah? And the Gemara answers, it is derived as a principle from the case of offerings slaughtered outside by means of an analogy, right? We learned a source for you can appoint an agent and you're legally bound by what the agent does. We learned exceptions where you can even appoint an agent to do something and he commits a transgression and you're liable. Those are just the exceptions. But the general principle is if you appoint an agent to commit a transgression for you and he knows he's committing a transgression, so he's guilty for that transgression, not his principal. And how do we know this? This is by means of an analogy. But before deriving that an agent cannot be appointed to perform a transgression from the case of offerings slaughtered outside the temple, let us derive that law from these other cases, the ones we've already been talking about. misuse of consecrated property, and slaughter or sale of a stolen cow or sheep, where the law is that an agent can be appointed to perform a transgression. And the Gemara answers, the merciful one again writes in that same verse in connection to the prohibition of slaughtering offerings outside the temple, Leviticus 17:4, and that man, Hahu, shall be cut off from among his people. If the law derived from the emphasis of the word Hahu, that man, written in this part of the verse, is not needed for this matter itself, since the verse already taught that he is liable only for his own act and not for that of his agent. Apply it to the matter of the entire Torah, so that one is held liable only for one's own actions and not for that of an agent. So the Gemara asks, and according to the one who says that two verses that come as one do not teach a precedent, and there is no reason to learn from the misuse of consecrated property and slaughter or sale that one can appoint an agent to perform a transgression, what does he interpret these terms, that man and that man, to be teaching? Since he does not need to counter a derivation from the two verses, he should not require them to teach that one cannot appoint an agent to perform a transgression. And the Gemara answers, one of them serves to exclude from liability the case of two who hold a knife and slaughter an offering outside together, and the other one emphasizes that man is liable, but not one who is compelled to slaughter the animal. That man is liable, but not one who does so unwittingly, and that man is liable and not one who was mistaken. Right? You're not liable for a transgression that you didn't know you were committing in a situation where you had no reason to know. You weren't negligent in not knowing. You just had no reason why you would have known, or you were tortured in order to do it, or you did it by mistake or unwittingly. Okay, that's not a liability that you're going to incur. And the Gemara asks, and how does the other opinion, i.e. the one who holds that two verses that come as one do teach a precedent, which derives from that word, hahu, that an agent cannot be appointed to perform a transgression, how does he derive these laws that the person who does so unwittingly or mistakenly or through coercion is not going to be guilty? Where does he get that law? And the Gemara answers, he derives those laws from the fact that the pronoun hahu is composed of two parts, the article ha, meaning the, and the pronoun hu, meaning he. So he derives the laws of both from who and from the additional article hahu. Therefore, he is able to derive both the principle that an agent cannot be appointed to perform a transgression and the laws of two that slaughter and one who acts without full awareness. And the other opinion, i.e. the one who holds that two verses that come as one do not teach a precedent, which derives these laws from the entire word hahu, he does not interpret the variation from hu to hahu. He holds that one cannot derive separate laws from each part of this word. So the Gemara questions the statement that there is no agency for transgressions. But there is that which is taught in a baraisa. One who says to his agent, go kill a person. He, the killer, is liable if he kills, and the one who appointed him is exempt. Really? Shammai the elder says, in the name of Haggai the prophet, the one who appointed him is liable, as it is stated with regard to David, who directed Joab to kill Uriah. Him you have slain with the sword of the children of Ammon. Right? In the incident of David and Bathsheba, and David sent Joab to take Uriah, her husband, to the front lines in the army so that maybe he would perish in battle. And that's what he did. And then he was able to go collect Bathsheba. So who's responsible for killing Uriah? Is it the enemy soldiers? They're just doing what they do in war. Is it Joab, who is acting as David's agent, who is told, go put that man in the front lines? Or is it David, who sent that soldier to the front lines, with this ulterior motive so that he could get Bathsheba, right? This was, some say in the Talmud that David was actually acting correctly, but most opinions say, and the prophet, right, Nathan said to David, what are you doing? You're a rich man who can have any woman in the kingdom. Why are you taking the wife of this one guy? You're like a rich man who has all the sheep in the world, and he takes the one sheep that a poor man owns. Right, we see that story in the David story in the Bible. So, is not David the one who committed the action? So the Gemara asks, well, what is the reason for this statement of Shammai the elder? How can we say that there is agency for transgression? And the Gemara answers, he holds that two verses that come as one do teach a precedent, and therefore he learns from the two cases of misuse of consecrated property and slaughter or sale that there is agency for transgression. And as for the derivation from one who slaughters an offering outside the temple, which teaches that there is no agent for transgression, Shammai does not interpret the variations from hu to ha-hu. And if you wish, say instead, actually it is possible that he does interpret the variation, and he agrees that there is no agent for transgression. And what is the meaning of Shammai's statement that the one who appoints this agent for transgression is liable? It means he is liable according to the laws of heaven, although he cannot be punished by a human court. Now, somebody who enters into a conspiracy to commit a crime, or one who hires an assassin to go kill someone else, obviously he's guilty. So what's different here? We're not getting fully into the nuances of this yet. The Gemara asks, by inference, does this mean that the first Tana holds that he is exempt even according to the laws of heaven? The one who appointed him must bear some responsibility for sending someone to kill. Rather, the first Tana also agrees that the one who appointed the killer is liable according to the laws of heaven, and the difference between them pertains to a great judgment and a small judgment. According to Shammai, his liability is great, to the extent that heaven considers him fully responsible for the killing, whereas the first Tana holds that his liability is of a lesser degree than the agent who actually performed the killing. And if you wish, say instead, everyone agrees that there is no agent for transgression. And nevertheless, Shammai holds that there, with regard to killing, it is different, since the merciful one reveals, him you have slain with the sword of the children of Ammon, explicitly rendering David accountable for this transgression and indicating that killing is different from all other transgressions. And the other opinion, meaning the first Tana who holds that the one who appoints the killer is exempt, explains the verse as follows, behold, this killing is for you like the sword of Ammon. Just as you are not punished for those killed by the sword of Ammon in the course of the war, so too you are not punished for the death of Uriah the Hittite, not even according to the laws of heaven. And what is the reason for this? Uriah was a rebel against the monarchy and was consequently liable to the death penalty. Why? Because he said to King David, and my lord Joab and the servants of my lord are encamped in the open field. 2 Samuel 11:11. By referring to Joab as his lord in front of the king, he indicated that he answered to Joab rather than to the king, which is tantamount to rebellion. Rava says, and now we're very close to done. Questions or comments, please get them in. Rava said, if you say that Shammai holds that two verses that come as one do teach a precedent, and he does not interpret the variation from hu to ha-hu, the combination of which would result in him holding that there is agency for transgression in all cases, even he concedes with regard to one who says to his agent, go and engage in sexual intercourse with a forbidden relative, or go and eat forbidden fat, that the agent is liable and the one who appointed him is exempt, as we have not found in the entire Torah a case where this person physically benefits for the transgression, but that one becomes liable. Right? So if I say to you, hey, you know what? Why don't you just go eat some pork? You're a Jew, and I say, just go eat some pork. Go ahead, enjoy yourself. It's not for me, but you go enjoy yourself. And then you go and do it. You're certainly liable if you're a Jew that ate pork and you committed that transgression. Am I liable? No, not like one who eats pork. Maybe I'm liable for giving bad counsel, for giving bad advice, for urging you to do something that you shouldn't have done, for manipulating you into doing that. Those are actually some of the transgressions that we atone for on Yom Kippur. We mention them specifically, that we give bad advice, that we're manipulative, that we, get others to go do bad things. But we're not liable for the same transgression, right? You're liable for eating the pork. I'm liable for giving bad advice or being manipulative, etc. It's a different liability. Okay, that's what I've got for us today. I'll take some comments and questions. Remember, Tonight begins Yom Kippur. Tomorrow night, after Yom Kippur ends, we'll break the fast, go to bed. No class tomorrow night. And we'll resume on the regular schedule on Tuesday at 6 p.m. Pacific. Okay, a couple of questions on Kiddushin 42. And Nina says no questions. So that's what I've got for us today. May you have a meaningful fast, and may you have an uplifting, utterly uplifting Yom Kippur. Our Father in heaven, wants us to come clean and forgive us and push that holy reset button so that we can enter cleansed and purified into the new year. And may you feel the joy of